Good afternoon, everyone. Welcome to our weekly COVID webinar here at Frantic PC. This week, our session is focused on an issue that I know we're all thinking about a lot these days, labor in the time of COVID. I'm Jackie Godapur-Werns, and I'm excited to welcome you today. With me are a number of the Frantic COVID team members you've come to know and trust: Shelly Anderson.
Hi, everyone.
Nikki Baser.
Hi, everyone.
And Dana Fattori-Crumley. And we're pleased to also have our partner Jennifer Dunn with us today to talk about all things labor in the time of COVID. Welcome, Jennifer.
Hi.
So before we get started, I'll just tell you our normal housekeeping reminders. Please submit your questions through the Q&A function on Zoom. It is much easier for us to keep track of and answer your questions there than in the chat. But we do also love to hear from you in the chat if you have any thoughts along the way. And also please mark your calendar for next week's webinar, which is the next installment of our equity webinar series. So next week, our webinar is going to address the role of the equity administrator. And we're very excited to have guest speakers, Dr. Teresa Lance, Assistant Superintendent of Equity and Innovation at School District U46, and Adrian Harris, Director of Diversity, Equity, and Inclusion at Community Unit School District 300. And they're going to be talking about what the role of an equity administrator entails, including things like training and role responsibilities, successful equity initiatives, as well as the challenges administrators can face in achieving success. So please make sure to watch your email for registration details for that webinar. And as always, please submit any questions that you may have to us. You can reach us at covid@frantic.com or events@frantic.com if you ever have any questions for us for our webinars. And of course, if we don't get to anything today that you would like to discuss, please feel free to reach out to any one of us or any other Frantic attorney for more assistance. Okay, well, let's jump in and start talking about labor. So Jennifer, I know that there's been a lot of activity at the Illinois Educational Labor Relations Board recently. Can you start off with a little primer on the IELRB, injunctive relief, and how the IELRB handles these cases?
Thanks, Jackie. This question tends to bring out the labor history geek in me, so I'll try to keep that tempered just a bit. You know, there's a long history in this country of the use of injunctions in labor disputes, much longer than we have time for today. And obviously, we want to focus on the injunctive relief that is available to the parties under the Illinois Educational Labor Relations Act. This is worth a refresher as the kickoff to this discussion because, as you've noted, there have been a series of cases within the last couple of months where injunctive relief has played a prominent role in the negotiations between educational employers and the unions that represent their employees as they confront and navigate decisions about reopening and returning to in-person learning. So let's start with the basics. You know, as a general matter, injunctive relief is an extraordinary remedy. And I mean that in terms of both the rare cases where this exceedingly high threshold or legal standard has been and can be met, as well as the nature of the remedy itself. You know, basically stopping the parties in their tracks when we talk about it in terms of bargaining in good faith. You know, there are two basic avenues of injunctive relief under the IELRA. First, and the far less frequently sought out or invoked, is the ability of educational employers to seek an injunction directly in circuit court to enjoin a strike by their employees that the employer believes poses a clear and present danger to the health and safety of the public. This is a very narrow standard to begin with, and it's worth noting. Many other public sector labor statutes refer to enjoining strikes under a similar standard, but refer to not just public health and safety, but also public welfare. And that's proven to be over the course of time a far more nebulous term and open to much more judicial interpretation. And the drafters of the IELRA were very well aware of that and chose a far narrower standard. In addition, note that this type of injunctive relief action against a strike, it doesn't require any sort of proceeding first at the IELRB. It's a direct avenue for employers to proceed directly into circuit court for an injunction. But it's rarely sought, and it's even more rarely granted. Off the top of my head, I can think of a few cases, where it's been sought, even fewer cases where it's been granted. And the most recent case where we can think of an instance where a court has enjoined a strike by educational employees involved the University of Illinois healthcare system and its nurses. And note that that injunction didn't enjoin the entire strike, it enjoined a portion of that strike by certain employees because striking nurses posed a direct threat to patient health and patient care. Second, far more common, but still rare in and of itself, is the type of injunctive relief you're going to hear us talk about, specifically with respect to the cases we're referencing. And that's the IELRB, the agency that enforces the IELRA, their authority to pursue injunctive relief in circuit court under Section 16D of the IELRA. There's a statutory threshold involved in those types of cases, and it requires that the IELRB essentially find that an unfair labor practice charge has some sort of merit and it warrants going forward. Only in that instance, where a complaint for hearing is going to go forward on a particular ULP charge, will the IELRB actually consider a party's request for injunctive relief. So it's in conjunction with a ULP charge that is already, deemed to have some merit. So in those cases, the IELRB considers, should an injunction go forward while that charge is pending? A few things worth noting. Number one, that charging party asking for that type of relief doesn't have to just be a union, it can be an employer as well. It's whoever is pursuing that ULP charge. And in contrast to what we just talked about, or what I just mentioned, this doesn't allow either party, either the union or the employer, to go directly into circuit court. You are starting with the IELRB, you are meeting that threshold on the ULP charge, and then you're making your case to the IELRB about, yes, we want you to pursue injunctive relief on our behalf. So what standards, essentially does the IELRB look at? They're considering, is the charging party, do they, have a significant likelihood of prevailing in their case? Are they more likely than not to win their case? And we're seeing these in ULP charges alleging refusals to bargain in good faith, and really involving a lot of questions about mandatory subjects of bargaining and unilateral changes. Assuming you convince the IELRB that injunctive relief or that your case is going to go forward and you have a good chance of winning, the IELRB then considers whether injunctive relief is just and proper. And that's where we see a lot of different types of factors, traditional factors, considering whether we do this type of extraordinary relief. Is irreparable harm going to occur if we don't do this? Is the public interest really implicated here such that an injunction is warranted? So those are the two types of injunctive relief we see under the IELRA, and that is most common, and that we're seeing most recently in the cases we're going to talk about. I think Nikki has teed up for us.
Yeah, Nikki, so based on that, sort of in that introduction, can you tell us about the specific cases that we've been seeing recently in this area?
Sure, and in fact, I think, we have, as Jennifer noted, the most common is to go through the IELRB process. We've seen that mostly lately, although we did see a school district just go in to try to get relief directly from the circuit court related to a strike, and I'll talk about that in a moment. But as Jen said, these are arising right now as districts have either sought to open for the first time or reopen after a pause, and have experienced, in some case, obviously significant union pushback. And so what we're seeing is unions filing grievances, often based on provisions in their contracts that require, that they are teaching in healthy and safe conditions. So they'll file the grievance, but then they're also filing ULPs, as Jen mentioned, essentially alleging that the district, by unilaterally announcing a reopening, that the district has violated the act by refusing to bargain over health and safety issues that are mandatory subjects of bargaining. And so, we have seen a number of cases as Jen said, over the last couple of months of educational institutions go through this process where unions are filing these ULP charges and then seeking injunctive relief. It's been really interesting to look at how these cases have come out because they have really come out very differently depending on what has happened on the ground. And so, you know, these are very fact-specific inquiries, and the labor board's decision really have been based on those specific facts of the case. What is crucial to understand, I think critical in all of these across the board, is that the IELRB has taken the firm position that employee safety in the midst of this COVID epidemic is a mandatory subject of bargaining. And they've sort of, to go down the rabbit hole a little bit of how we think about labor issues, right? So I think districts' positions have been that they have the right and the authority to make the decision about reopening, and that they are required then to bargain the impact of that decision. So the health and safety impact of that decision, should the union request to do so. I think what the IELRB is doing, and I'd be interested to hear Jen and Shelley's takes on some of these decisions, is that they're sort of intertwining these in a way. They are saying essentially that the decision to reopen and the issue of health and safety are intertwined such that districts have to be bargaining these issues with their unions. Again, what we've seen though is that, and we have in fact been successful in representing districts in front of the IELRB on these motions for injunctive relief, based either on the fact that, you know, the facts on the ground are such that the district did bargain these issues and reached agreement, or the union just didn't seek to bargain at all, or because there are issues of law and fact. And I think, you know, everybody is very aware of the CPS CTU negotiations that are ongoing. There have been 2 hearings in front of the IELRB, and based on law that's very specific to CPS, or is only specific to CPS, there's been, the IELRB has declined to seek injunctive relief, saying that there are just issues of law and fact that prevent them from doing so. Again, we've seen the opposite with some other school districts who've gone in, a union has gone in and has successfully argued in front of the IELRB that either the district didn't bargain to impasse, or they violated a previously established memorandum of agreement or the like. And as I mentioned, we also saw a school district go in under that health and safety exception that Jen cited to seek an injunction related to a strike, and got shot down in circuit court. So the long and the short of this is that there's a real mixed bag out there as to what is happening when these issues are reaching a head. And so if you are experiencing significant pushback from your unions, this is really a time to involve your attorneys in your bargaining, and to before you make any decisions, to really touch base on whether you fulfilled your bargaining obligations, because you could be ending up in front of the IELRB on these issues.
Nikki, if I can just add something to that, I think the interesting thing and the component here that we have in the midst of a pandemic is that things are happening so fast, and they have to be happening so fast, because the idea being, any time lost for kids for instruction for many districts is too much time. So how do we, as quickly as possible, get kids back in school? And for boards to making those decisions, it requires, obviously, they have to, if it's the board making the decision versus the superintendent, making sure there's time for posting of the agenda for a special board meeting. When are you meeting with the union? When are you having this discussion? And those decisions that have come out to say that those districts where they did approve of the injunction, that the district came out and kind of made a decision unilaterally without first discussing it with the union. And I think there is the component to it, is, whether or not the decision is to be made by the school district or not. And certainly that has been the position of many of us who work on the other side, that the decision is up to the school district. That doesn't mean you shouldn't be discussing it with the union as much as you can, but with the recognition that because things are changing so fast and we have to make decisions so quickly, it really requires kind of a constant dialogue and communication as to what the changes are going to be and what the plans are, as much as you can through the process.
I think that's a great point.
So then another facet of this, of course, is when you're describing what happens when the parties can't come to an agreement at the table. So Jen, can you walk us through what is that process, and what are the strike requirements? Can a union even strike mid-contract over COVID issues?
Sure. So we want to discuss this framework because, you know, successor contract negotiations haven't stopped simply because we're in the midst of a pandemic and dealing with and confronting issues about returning to in-person learning. There isn't, in fact, an adaptive pause, to borrow that term, on the bargaining process. If anything, you know, the requirements about strikes, the public posting process, these have taken on sort of greater importance in the midst of these types of negotiations. So let's just begin with the basic requirements for a lawful strike under the IELRA. You know, the law is very, very clear, and I think we've made this distinction, but when we talk about educational employees today, we're talking about them outside of the CPS context because there are a lot of very nuanced specific requirements applicable just to CPS and its employees under the law. And we're not really talking about that today. So IELRA's requirements are very clear for an educational or a group of educational employees for their strike to be lawful. It's only lawful if the following conditions are satisfied. Number one, they need to be represented by an exclusive bargaining representative. That means they're represented by a labor union that has, you know, majority support of those employees. Number two, mediation has to have been used without success, and at least 14 days have elapsed after the IELRB has made public the parties' most recent offers and cost summaries. So it's really sort of a two-part requirement. Number three, at least 10 days have elapsed after a notice of intent to strike has been given by the union. Number four, the parties' collective bargaining agreement has expired. And number five, the parties have not agreed to submit their unresolved issues to arbitration. And by arbitration, I don't mean, and the statute doesn't mean grievance arbitration. We're talking about interest arbitration, where the parties agree, look, we can't reach a voluntary agreement on a successor contract, and we want a neutral third party or maybe a three-person panel. We want to give them the ability to decide these contract terms. And they go through a process known as interest arbitration. Assuming that that requirement has to be satisfied, meaning they are not going to go to that process. You know, note that there are no exceptions to these strike requirements. The Illinois General Assembly did not legislate any exceptions. So, you know, in fact, it speaks in terms of employees not having the right to strike except under these conditions and when they are satisfied. So the notion that we're in the midst of a global pandemic, or the notion that a safety issue allows educational employees the unfettered right to strike, or to ignore that, you know, they're mid-contract and the collective bargaining agreement remains effective, that position is really flying in the face of the statutory language and these requirements. It's essentially contradicted by that plain language. There is that requirement I referenced about the public posting process, and I think Shelley mentioned it as well. That is a refresher we think should be in everybody's mind as well. We had this amendment come into the law a few years ago, and it sort of imposes what we'll call a cooling off period. We've heard that term bandied about a little bit in the media in connection with the CPS-CTU negotiations. This process sort of, again, imposes some certain timeframes where the parties do have to pause. They have to run through these hoops, essentially, where they can't strike. The union wouldn't be able to strike until 14 days after the IELRB has posted offers and cost summaries. But we really have to back out from that, sort of this formula. And we have to get that process started. And that process can't even get started until you've already started mediation. Because the public posting process can't be initiated unless 15 days have passed since your first mediation session with the mediator. Assuming that has happened and you're in that window, you then initiate the public posting process at the IELRB. Within 7 days of that filing, you are then submitting those offers and cost summaries, and within 7 days after that, the IELRB is posting. So again, building in these natural sort of cooling off periods, giving parties the ability without the public really knowing exactly what the offers are, what the numbers are, giving them the opportunity to continue to negotiate and see if they can reach an agreement. And then once the IELRB posts on their website and it's, you know, distributed to the media, bringing that public pressure to their negotiations, again, to try to bring about a conclusion to what otherwise is an impasse. But all of those steps really need to be satisfied in addition to the other statutory requirements on a strike. So this idea of a midterm contract strike I think is ignoring what the statute specifically provides.
Yeah, and interestingly, Jen, I don't know if you've noticed, and I've had cause to look as of late, but there has not been a public posting since March of last year. Was the last one we saw. I think that now that things are changing a bit and people are actually back into negotiating, where maybe they'd put it on hold, we're likely to see that process start again. But I did think it was interesting that we haven't had one since right before March 13th of last year, by last time I looked.
Sounds about right. And as we start finding ourselves back into this process, it's always a good idea to reach out, talk to one of your favorite labor attorneys here on this webinar to help you navigate that process.
Very interesting stuff. All right, well, Shelley, let's move over to some employment related reopening issues. So first of all, some schools are moving to 3 or 3.5 feet of social distancing. What is behind that, and what are the unions saying about it?
Yeah, so I think that for those districts who have been successful at having a group of kids in, so if they've done, group A or group B on different days or varying weeks, and they've had success with it and seen that there has been, little to no transmission within the school, whether it's because they determine that the administration or board themselves wants the kids in more, or perhaps the community pressure to get the kids in more. They've been determining whether or not they're able to do so without keeping what may have been initially deemed to be the best course of action, which was 6 feet of social distancing between the kids. And certainly that's what ISB came out and said, whenever possible. And there's been a lot of discussion, I know, between boards and superintendents and their unions about what does that mean? What does whenever possible mean? And does that mean that if you can't ever do it, that's enough? And the important thing is getting kids back. Now, certainly everything we've seen from the governor's office to ISB to IDPH, CDC, everyone's saying kind of get kids back in. So how does that play then with the idea of social distancing? What I've seen as of late, or for those districts who were able to do it successfully in the beginning with keeping less kids in the building and 6 feet, now moving to a situation where we can get more kids in more often if they're only 3 feet apart. And a lot of that, most of that is coming from the American Pediatrics Association saying that that is a sufficient amount of space, especially for the littler kids. So the little kids, K through 8, K2 maybe, who are less likely to transmit COVID, even if they were exposed to it, that amount of distance is safe. And really the focus has been on mask wearing, right? Like if you are wearing masks, 3 feet is deemed to be a safe amount of distance. Now, union pushback, as you can imagine from the teachers, it's scary. The idea of being, well, we had kids 6 feet apart and I felt safe, but now that there's more kids in here and they're only 3 feet apart, teachers might not feel as safe. So working with the union on what does that look like and what can we do to address your concerns about that. And one thing that we have done is, where possible, made sure that a room is set up so that if the kids are 3 feet apart, they can still be 6 feet from the teacher. And we have done things in districts where there's, a tape line around the teacher's desk. We've also had teachers request plexiglass around their desks or 6 feet to make sure that kids remember, kind of they can visually see where the 6 feet marker is. And that seems to have helped a bit, providing more PPE for those teachers. And really just having an open dialogue about what else can we do to make you feel safe in this environment if the interest is to have more kids in more often. That's certainly one thing that we're seeing. And there have been many districts who've done it successfully. We're getting some pushback in other places as to how we can most effectively do this. But again, you never know kind of what the solution is going to be until you open the dialogue and have as much conversation as you can with your union and your teachers around kind of what their real concerns are and how we can best address those. So that's kind of what we're seeing out there right now.
All right, Dana, we are still seeing a lot of testing at districts, both staff and students. Are we seeing any mandatory testing of students, and what are the legal implications of it? And also, if you would, tying it to our labor issues, is any of this coming from union concerns?
So yes, I think all of these issues play into union concerns. Everything that the union is bargaining, it's not just it's not just distance, as Shelley said, like whether the kids are 3 feet away from each other or 6 feet. It's also, what the ventilation system is, what your protocol is for screening. Are you screening? Do you have contact tracing? And testing is a big issue. And we do have districts that have imposed mandatory testing for kids that want to be on campus, for students, not for teachers. But if you want to come on campus, you have to do, and it's more screening. It's not really the positive, the PCR, whatever the initials are for the test. I don't have that on the tip of my tongue, but screening is mandatory for coming to the building. So kids are doing the tests that are the saliva-based tests. They're screening, and I think that gives teachers a measure of reassurance that the district is doing everything it can. I think as long as you have a way for students to object to that or opt out or have a hearing of it, we really haven't had a great amount of pushback. And we have other clients considering that, because I do think it gives the teachers greater comfort. That being said, not all districts can afford to implement testing or screening for everybody. So I think it really reiterates everything that everyone's been talking about. There is no roadmap that we can give you in this 1 hour that is going to solve all these problems. It really is something that you have to look at your situation, your district, consult with your council and with your union to sort of figure out the path ahead. Because what works for one place is not going to work for the other, and people have very local concerns.
Well, anytime we talk about testing, we have to also now talk about the exciting news of vaccination. So one of the really amazing things that we're seeing is that our educators are starting to get vaccinated. And of course, with any good thing comes questions about what happens now that the teachers are vaccinated. So Nikki, can you start out by talking us through what accommodation questions may arise with respect to vaccinations?
Sure. And I know we have lots of thoughts on the vaccine question, so I'll just start us off and let everybody else weigh in. So I think that there are two different sets of employees at issue here. So the first is the employees that have received the vaccination and who are currently out teaching remotely with an accommodation, maybe teaching remotely or out with an accommodation otherwise. So I think for those employees, the question is the receipt of the vaccine, is that going to enable them to return in person to the school building? And I think that is, something that districts, again, need to start. All of these are going to be individualized inquiries, and you're going to need to talk with those employees. But I think it's a good idea to think through, how, giving the union a heads up, we're going to start talking to employees. We want to figure out these issues. I think the other category of employees are those who, if at this point, we're not seeing a lot of districts mandate vaccines. So if you are encouraging folks to get vaccines, what about the group of employees who didn't get a vaccine and also are out of the classroom, out of the school building with an accommodation? And so again, I think, first of all, you need to work through individually with those employees, the reason, whether they've gotten a vaccine, maybe they got a vaccine outside of the district's program, and you need to find that out. And if not, are they, do they have a medical reason or a religious reason? And start the interactive process on, is there, could they get a vaccine? Can they come back? And, have that communication. I think, so you need to think about these in sort of two different sets. And I don't know if Dana or Shelley, you guys want to sort of jump in here too, and what you're saying and what you're thinking through.
I definitely think one thing that I've been doing with the vaccine coming on the forefront is as districts sort of as things are changing, making sure that regardless of whether people are getting the vaccine, to put a time limit on the accommodation of work from home, so that you're not just in this land where, we're letting you work from home from now until May 1st, because the vaccine could come before that. So I don't know if that's a ship that has sailed for some people. But I think there's also specifics about the vaccine. We have to, wait till, follow the guidance as to when it's effective and understand the limitations of it. Obviously, it's not going to be end it all instantly. We're still going to be wearing masks and taking other precautions. And then I think if you have teachers that are refusing to get the vaccine, what impact does that have on their leave? I think you're going to have a more communication with their physician about why they're actually refusing. And this is so time consuming. So I know people get frustrated by this. And I was thinking, that might be an area of development, is to develop some sort of questionnaire or something that employees can provide to the physician about guidance on the vaccine and why they're not getting it and why they still can't come back after they've received it. I think we're already getting those requests, then to be proactive and thinking about that might be a good idea.
Yeah, I definitely think that, when you were looking at the vaccination and what impact that's going to have on any accommodations that have been made, you have to think of it as, are you a school district who has allowed teachers to work from home or not? And alternatively, are there individuals who are on an FMLA leave because they were not permitted to work remotely, that once they are vaccinated will be perhaps coming off of that FMLA leave or be able to come off early, and really just starting that process with all of the folks who've been either allowed to work from home or on leaves as early as possible, so that you have a sense of kind of how this is going to change and transition once the vaccinations are available to everyone. And I know so many districts are working with their unions and their teachers together to get people vaccinated as quickly as possible, to try to make some changes, coming up perhaps after spring break or soon thereafter. So the earlier you can get working on this and determining what changes might need to be made, the better. So.
Yeah, we just got a question in the chat that maybe we want to tackle too, just about, if a teacher is granted an accommodation to work remotely because of their own medical issue that puts them at high risk, and then subsequently contracts COVID and then fully recovers, are we on solid ground to expect the teacher to return in person? I think possibly. I think we would want to get information from their physician. I mean, I think it's a really good question. But I think at that point, if they've shared with you that they've got COVID and there may be some immunities there, obviously, you would want to request and seek updated doctor's information and engage with them just like you would with any other employees on whether there's a possibility for return, at this point. And I know, Jennifer, I know when we were talking about this in advance, we were talking about, should we require, at what point should the district require mandating the vaccine? And, is that something we want to think about, and what the implications are related to then if someone doesn't, their accommodations?
Well, certainly, requiring vaccines for any employees who are in a bargaining unit, I think for me, it raises an issue about bargaining and how they're going to have to approach this, because at some point they're going to have to approach it at the table. Whether the decision itself is going to be mandatorily negotiable or frankly the impact. And I think the impact is where you'll see a lot of both the accommodation issues as well as any sort of performance issue. If it's, if you don't receive it, are you going to be disciplined? Or if you don't comply with the requirement, are you going to be disciplined? And I think that kind of navigating that kind of issue on top of everything else that's at the table, I don't see a lot of employers necessarily going down that road, but it certainly has a lot of bargaining implications.
We also did receive another question. What about an employee who needs to be vaccinated? We provided them an appointment, but they declined because they're out of state while on leave and don't know when they'll return to the area. And I think in that situation, we need to look at, why is the employee on leave and how long is their leave set for? Because if they've already been granted a leave for a certain amount of time, certainly they're not then expected to come back unless there was some sort of arrangement made that they come back earlier. I think it's certainly unfortunate if they're, passing up an opportunity to get a vaccination, but if they've gone out of state, maybe there's another way they can do that. But for those employees, I would say you expected them to be on leave for whatever that duration was. And if they're not going to be available for the vaccination, Whatever the requirement is upon coming back, though, the expectation will be that they have found another way to get it if that's the expectation for returning to in-person instruction whenever their leave is up.
Okay, well, I think we got to most of the questions in the chat there. Some of them in the Q&A are coming through like in bits and pieces. So if for some reason we didn't get to your question about vaccines, just type it again in the Q&A for us, and we'll get to it when we get to the end and we start going through our questions. All right, so then Shelley, let's talk about non-renewals and RIFs. So the season for non-renewals and RIFs is upon us, is approaching. So can you remind our listeners about that process and what are the labor implications that come along with it?
I will, and I will say, you know, I feel like, you know, I guess Groundhog's Day was just 2 days ago, or 2 days ago, maybe, you know, feels like a full year. And I think this was one of the very first topics we covered in our first webinar almost a year ago now, because it was in March then as well. But in terms of kind of where you're at in that process is that, you know, as we all know, we've been doing this for the last few years, since 11-12, that before, you know, 75 days before the end of the school term, which is right about now, for those of you who are not on this yet, you need to be, you know, giving a list with the union of the names of all the teachers, what categories they fall in, and what their groupings are for purposes of a sequence of honorable dismissal list. And you need to do that under the law, even if you don't think you're going to be doing any honorable dismissal. So making sure that you have that process done with the union so that you can both look at that list and determine where everyone falls out. And then the one caveat to that being that individuals who were in group 1 can move to another group anytime between 75 days and 45 days for the school term. Now, there were so many differences and changes done to the evaluation process because of COVID, just making sure that you know where everyone's grouping falls based upon their ratings and what you're looking at. Be a good time to make sure you take another look at that and know where you're at. You know, as I mentioned, since 11-12, we now have one time period for both non-renewals and honorable dismissals. So that's 45 days for the end of the school term. And that's board action and notice to the teacher 45 days before. And I just want to make sure that, you know, we say this whenever we talk about this topic, but just remembering that a non-renewal for a probationary teacher still exists live and well. You should be using it. You should not be honorably dismissing probationary teachers who you don't think you have a place for the following year for whatever issue has come up with respect to their performance. Use that non-renewal tool, because that way they, you know, don't have the recall rights that they would otherwise if they're having an honorable dismissal. With this time of year, I also just want to make sure that while it doesn't directly for your first part of this decision have a labor implication, it does on the second part. And that is with respect to administrators who you may have to be non-renewing, who may have tenure in your district. So remember that if an administrator is with you for, depending upon what ratings they've gotten as well, that's a whole other question, but let's just assume kind of regular track here. You have an administrator who's been with you for 4 years or more on single year contracts. They have tenure in your district, which means that if you are going to non-renew their administrator contract, they have the right to be placed back into a teaching position. And so you want to look at what's your past practice then? What does your collective bargaining agreement say? Is there some way you determine, usually with union leadership, where that person is going to fall if you have a salary schedule? So for instance, are there years as an administrator going to be counted towards seniority on the schedule or not? And so that's the labor part of it, as well as when you are looking at a sequence of honorable dismissal list, where does that administrator fall, such that if you needed to release someone, are they actually bumping someone else, a teacher who was in the bargaining unit before? So that's the labor part of it. And that's why it's so important that these things be done kind of at the same time, even though we don't necessarily look at that same time frame typically for administrators and teachers, but they do have a really significant impact on one another. So making sure that you're looking at kind of the whole picture of staffing of what it's going to look like at both the administrator and teacher level between now and certainly the end of March.
Okay. All right, let's get to the questions that we received from our listeners in advance of the webinar. So a number of our listeners asked about labor relations generally in the time of COVID, and I know that we've talked about that some here, but can you each give us a sense of what that looks like generally in the districts you're working with?
I can start. I think we can safely say it's been a mixed bag. I think we have some districts that have, for a variety of reasons, been able to navigate with their unions through this, fairly successfully. You know, Either, it based on a variety of factors, just what was happening with the district, how large the district is, the relationship prior to COVID, certainly, what their reopening plans have looked like, and ultimately just the positions that the unions have taken on these. I mean, we talked a lot earlier about unions and our involvement in some cases that have ended up, in the IELRB. So obviously there have been some districts where this has been a much more difficult time to navigate. And I know we've talked about this before on this webinar. I think we have seen even districts with really good union management relationships prior to COVID ending up in really contentious situations. And it's an unfortunate piece of this pandemic. Our hope obviously is that these relationships become normalized again and we're able to get back on solid footing. But I think there have been some real rifts in what have previously been positive relationships, because there's a lot of, as we know, as you guys know better than we do, there's a lot of various contending issues and concerns here. And so I think, we have seen the full gamut within the COVID pandemic.
Yeah, I would say that's right, Nikki. And I think it really does relate back to what I said earlier about the timing of which everything needs to happen, is that typically where we would have more time to have more discussions and maybe brainstorm more creative ideas and get more input from more people, that's just not possible right now with the speed of which everything needs to happen and how it's changing so quickly. So I think that, as Nikki said, I think that is attributed a lot to difficulty and tensions in relationships that otherwise, did have really solid footing. I think it also, making sure that you have the right people at the table to help make decisions is also key. So you don't have to kind of constantly be going back and determining who has authority to make what decisions is also a big piece of this to try to help move things along. My hope, well, I think what's going to be interesting is to see that contracts that are now up and who don't decide to roll over, and we engage in full bargaining for a successor contract, seeing how the impact of this on those relationships may impact that bargaining moving forward. And I think we had one question from one of our listeners early on about that, as in terms of, how is this going to impact moving forward? And I think it's going to depend on your community and your board. I mean, I really do. I think there are some communities and boards who've been very supportive of how great teachers have done, whether it's been remote or in person, whatever it looks like. And they've been able to really come together around this really difficult situation that we're in. And there might not be as much pushback. Alternatively, I think that for those districts where the community and board have been at odds with the union, walking into a full bargaining of a successor contract is going to be rough. And we're going to have to do some healing around that before we can kind of really get to a better place. And I think perhaps some districts are thinking of rollovers for that reason, to give us a little bit more time to take a breath, see where everyone's at, and kind of hopefully put the worst of this behind us and move forward together, because obviously that's ultimately what's going to be best for staff and our students.
Shelley, we just got a clarification question about, can you give a little bit more description or definition for 1 year rollover?
Sure. So, and I think we've talked about this before also, typically a 1 year rollover means that all you're doing is looking at compensation. So you're looking at maybe there's also insurance in there, but it's not a full bargain of everything you're talking with respect to language issues. So it would be a situation where you agree on what the compensation is going to be for the following year, and then everything else in the contract stays exactly the same. And you sign off that you're agreeing to roll over the existing contract, but for that, for 1 year after. And I know that happened in a number of districts I worked with last year who had their contracts up last year, and deciding now, are we going to do that again? Or is this something that we are going to now feel like we've had enough of the issues resolved that we're ready to enter into a full bargain? Nikki, I don't know, Dana, if you guys have had that happen as well with a 1 year rollover.
Yes, and I just wanted to add to it, it doesn't necessarily have to be just a one-year rollover. We've
Right.
seen multi-year rollovers as well. And we're walking into year 2 of this pandemic, and it's the idea that you need some more breathing room, it's not unheard of. So it doesn't necessarily need to be limited to, and it isn't always limited to, just a one-year rollover.
Yeah.
And if you did the one-year rollover, you're finding yourself back at the table right now, again, still in the midst of dealing with all of these pretty contentious issues.
Yeah, I think 1 year is probably, I mean, and of course, this is for the boards to decide and for the unions to decide mutually about what to do when the contract is up right now. Generally though, I think it's important to think about that we're going through a period of like huge change in working conditions, huge change in learning conditions, that even when the vaccine is rolled out and we're at that place that everyone talks about, normal, which seems like a really far way away, this is not going to just go away. This is going to change the way instruction is delivered. It's definitely changed parents' expectations of what they can get from school. And we have the parents that are very adamant about being back in school, but just as many parents, maybe not as well publicized, are like, well, why can't I just stay at home and have my school? And you're going to see parents wanting that. And that's going to change the job of a teacher going forward. So opening up the whole contract right now, I don't know if that's like a good use of time, considering everything else that's coming on the horizon, especially if you're not trapped into any provisions that really impede your operations or put you in sort of a financial straitjacket. Why wouldn't you look for a rollover for a few years? It just makes sense. And I think administrators also, you're relying a lot on your administrators to do the legwork of full-blown negotiations. And don't we want to be serving students now? I mean, this is a really important topic and we're all labor lawyers, but like school doesn't run, labor negotiations are not the only thing about public education. And, you have to always keep that in your mind, I think, especially when you're embroiled in it and you feel like you can't sleep. It's a good thing to tell yourself.
So another question that we received from a listener before the webinar addressed racial justice work and how it's looking with respect to unions and bargaining during the pandemic. So do any of you have any standout examples of union and management collaboration toward an equity agenda in the midst of COVID that you could talk about?
So, I mean, I think I'm going to give a caveat to this is, equity, again, sort of building on what I just said, equity is much larger than your labor contract. Equity is an issue that touches every part of the educational program. And labor is really about, and like, I guess I'm the only one here, I was a teachers union member. It's really about like, what do I get paid? I mean, they never want to say that it's about that, but it is about that because you put your heart and everyone cares about what they get paid. They put their heart and soul into their jobs, but also about what do I need to do my job and be successful at my job. And equity is so much broader than that. But that being said, you do have equity issues come up with teachers at the bargaining table. And maybe you've had some events in the district that have caused equity to really be at the forefront for teachers feeling that they need, they need training, they need support, they need help in navigating that and making, providing in their teaching that they need guidance and assistance. And we have had MOUs where the board and the teachers make a joint effort to look for ways that teachers can be trained, that board members can understand the importance of equity to different educational programs and hiring. So I think there's opportunities for that, but I also think equity is a bigger issue.
All right, and then another question that we received was thoughts on understanding the mindset that unions might have coming into negotiations. how do we balance teacher demands and financial uncertainty? How hard do we push at this still rather tenuous time? Are there specific requests that unions seem to want right now? Thoughts on that?
Well, I think this can all be wrapped up kind of in our whole discussion around kind of a one-year rollover. I think that that is, in terms of the best way to perhaps handle this right now, is because there is so much that is unknown to be on the table that I think many districts, maybe more so than unions, are wanting to look toward that. So I would say that there's so many different pieces of this that are, perhaps if you're entering into a 2-year contract or a 3-year contract, what is that going to look like? And for all the reasons that we've already discussed, I think looking at a potential rollover or narrowing of the issues, you also don't want to be spending a ton of time at the bargaining table for all the reasons that Dana mentioned before, when you have already so much on your plate, whether it's the board and everything you're deciding or administrators and everything on your plate. Adding a full bargain to it is a lot, and we appreciate that.
All right, then another question, can we add vaccination required to our postings for upcoming jobs and employment? I understand we aren't mandating it at this point for our current employers, but can we require it for new employees? Nikki, do you have thoughts on that?
Sure, but I just have to add first that while Dana is the only previous member of a teachers union, I was a member of the United Auto Workers at one point. I was technically a member of the United Legal Workers, which is a subset. So I have no actual marketable skills in the area of anything practical, but I did want to just point that out. Okay, so moving on, the vaccination posting. So this is an interesting question. So can you add a vaccination requirement to your job postings? So first and foremost, if this is an issue for a current position that's in one of your bargaining units, you have to bargain any changes to the job description with your union. And that is likely to foreclose this as a possibility. It seems unlikely that the union will agree to that. It's possible, but you do actually have to bargain that. So answer number one is that's your first step. If this position is not in a bargaining unit, so either it's a new job that is not going to be within one of these units, or it's just a job category that is not currently unionized at your district, it's possible that you could add this. It's really a matter of making the inquiry as to whether whether the job requires in-person attendance, and requiring a vaccine is job related and consistent with your business necessity. So for example, if this is a secretarial position that's not in a union, and you have secretaries right now working from home, I think you're going to have a hard time justifying adding that into your job posting. What I will say though, just in general, is if you are thinking of doing this, please talk to one of us, or please talk to your legal counsel before you do it. I think there's a lot of, again, if it's a union position, a lot of pitfalls there that you need to work through with your union. If it's not, still a lot of issues that we want to work through to make sure that you're doing this in the right way. So definitely a possibility, not a slam dunk.
All right, and then we had one additional question, which was, as staff are now seeking out their own vaccinations, we've had a request for the district to release and cover classes so staff can access their appointed time during the workday. What do we think about that? Do you need to allow it?
Well, if I've actually had this question come up at the table a couple of times, where the union is asking about, are they going to get, our teachers or our employees going to get additional paid time off to go and seek and obtain the vaccine, both at the first shot for the vaccine and the second shot. Obviously a bargaining issue. If you're going to grant additional paid time off for this, it's something you're going to have to negotiate. It's not something you're going to unilaterally grant to employees. So your bargaining agenda certainly factors into this, but also your decision about, are you requiring the vaccine, also would factor into it. And I know, Nikki, I think you may want to weigh in on how that might be compensated or not, depending on the circumstances.
Right. I mean, if you're requiring the vaccination, likely you're going to need to provide the time. And it's also, I think it gets a little bit complicated once you factor in if the district is going to be looking at these issues related to accommodation, if at some point down the line you're going to be denying accommodation because someone hasn't, been vaccinated but could be vaccinated. I mean, you need to sort of start factoring all of those in as to whether, I think Jen is absolutely right, which is for most of these employees, this is going to be a bargaining issue, but we do need to figure out the ramifications of it down the line if it's going to, again, if you're going to mandate vaccines or if you're going to start looking at that issue related to accommodation.
Can I just add one thing here? And I don't think we've said it, but I think is really important, is for all administrators out there who have teachers coming to them specifically saying, can you do this for me? Or can you do that for me? Or can I get some additional leave time? Or whether it's because I have a childcare issue or because I need to get vaccinated. We need to really remember that for those of you who are working with bargaining units, so you have a group, whether it's your support staff or your teachers, you cannot be dealing with those individuals individually. So even if you have the best of intentions, which I know so many of you who I work with do, and you want to say, well, I want to be able to give this person more leave time because it doesn't seem right because she, was exposed because her husband's an essential worker and she needs to stay home. Be making sure that you are working out those things with the union so you don't end up inadvertently having an unfair labor practice charge filed against you for individually working with those employees. So just a reminder on that piece of it, that kind of goes for all the different areas that we're talking about today.
All right, and then I think this is probably going to be our final question. Can we get confirmation that granting extra COVID sick days will be considered as over the annual allotment, and thus cause a TRS penalty for districts who have people retiring in the next 4 years? What should we be thinking about related to TRS when we enter into these leave agreements?
So this is a great question. It's been coming up a lot as of late. So I'm going to just say it for the 1000th time. FCRA has expired, everyone. It is gone. So if you enter into an MOU because you're deciding to give your staff additional leave time, do not call it FCRA leave. Please call it something else. TRS has come out with 2 bulletins. They both came out in January discussing how they're going to handle any additional leave that's provided. So for those of you, who are familiar with what happens when a teacher enters into their last 4 years, if they have what's considered excess sick leave, so above and beyond what teachers typically get, that can result in a penalty back to the school district. So there's an excess sick leave calculator that's on the TRS website. If you want to look at it, it can get costly very quickly. The reason I mention this is because what TRS said is that if you are following the same guidelines that FCRA had in terms of the amount of leave doesn't roll over, it's only the 10 days, it's only for these particular reasons, that those days themselves will not be considered as excess sick leave in the event they're granted through March 31st. They have not come out and talked about what those days will be treated as or how they might impact the district if they're granted after March 31st. I think we're likely to see something that comes out discussing that because there are many districts who've entered into MOUs with their unions because they want to afford teachers or staff additional days for quarantining and things like that. So, I would recommend that you talk to council. You can look at those 2 TRS bulletins that came out. Again, I think that we're likely to see something in the next month or so from TRS addressing how additional leave like that will be treated after the March 31st deadline.
All right, well, thank you all for your participation, for your questions, both before and during the webinar. Please feel free to reach out to any of us directly if we weren't able to get to your question. We did have a lot today, so thank you again. Thank you to our panelists, and please keep an eye out for next week. Our equity series is continuing, and this is a really exciting new series that we're offering, so we hope that you will join us for that. And until then, take care, everyone.